Counsel. Has defense counsel and the state had a chance to look at the exhibits on the thumb drive?
Yes.
Okay. And is there any objection to the exhibits on the thumb drive?
No.
Could I get a response from the state on the record?
Your Honor, we have reviewed it and we believe they're all accurate.
Okay. And has the defense had an opportunity to take a look at the laptop to ensure that it has nothing on it other than the exhibits and no internet capability?
We have not looked at the laptop yet. We reviewed the exhibits. We can look at the laptop right now and make
Okay. Why don't you do that?
We have something else though, if I could.
Yes.
Your Honor, the purpose of a rebuttal is to briefly and concisely address the key points in a defense argument. This particular rebuttal ran 14 minutes, which is almost as long as Mr. Gray argued. It was pre-typed, pre-outlined, with the design to go that long. It was not a rebuttal, it was a final argument. The amount of time that was used to exactly rebut Mr. Gray's argument was about 10 minutes. We repeatedly objected. I appreciate your overruling objection. We take our objection to your overruling, but it's not a rebuttal. This is a sandbag. He sandbagged us by preparing another final argument, which was unfair. So they've got an hour and 40 minutes of final arguments. And then we also object to the idea that we've advanced that in his dismissal of it, that because she didn't know that she had a gun, she couldn't have been aware that she didn't have a gun. That was Mr. Gray's central argument, and he's saying that is, invalid argument, but the court has permitted specifically that argument to be made. So he's rejecting a defense argument that the court is aware of or was aware of and permitted. And that's not rebuttal either. So we move for a mistrial.
Okay.
Judge, could I be
Mr. Frank.
Could I supplement that? State the angle requires that you know it's a gun. It's not should have known a gun or a risk. Straight out it says that. In his final argument, or excuse me, his rebuttal final argument, he said you didn't have to know it was a gun. That's one thing that's wrong. The other thing is that he says that the superseding cause is in the middle of some person's negligence. Well, that's not accurate either. A superseding cause, our client was using an authorized use of force, and the superseding cause, while she was doing it, which they claim was illegal, that she was illegally using a taser or a gun, and that superseding cause came while she was doing that, and they say, no, that's not the law. Well, it is the law. And that's another reason for a mistrial. Clearly, they said that you have this superseding causes in the middle of our client's, I don't know what, risk, whatever it was, but that's not the case. Thank you.
Did you want to respond, Mr. Frank?
Sure, Your Honor, I do. First of all, I guess didn't know I would be criticized for being prepared. I think the arguments were easily foreseeable, and I did, in fact, rebut Mr. Gray's arguments. If you recall him telling the jury, here are the bases upon which I think you can quit him. Didn't cause, right, so I addressed causation. She had a right to use deadly force, so I addressed her right to use deadly force. The statutes, conscious, has to be aware of it, so I addressed that. And I think the other thing is mistake, and I addressed that. My entire rebuttal argument was made in response to the very points that Mr. Gray made in his defense argument. There is no rule that I'm aware of that says if he says A, all I can say is not A. I am allowed to couch my argument in advocacy. And I don't have to just simply say, no, he was wrong. And that's what I did here. And I'm sorry if they found that more than they wanted to hear. But, Your Honor, as to the superseding cause, I can't help it that they chose to seize on that as something to try and convince the jury exists and it doesn't. I'm allowed to say they're simply wrong about that. I cited the law correctly. It's in their instruction. Mr. Gray even cited it correctly. It's not a superseding clause. It's not a superseding clause because Mr. Wright's conduct didn't come after. That's the legal definition of superseding clause. So was accurate. Your Honor, whether she has to know there is a gun in her hand, I think I was accurate about it. We don't have to prove. The court said, Mr. Gray, you can make that argument. That's the discussions we've had a couple of times. He made that argument. I rebutted that argument. That's what I did there. This was a proper rebuttal, proper in scope, properly limited. Sorry, I don't speak as fast as some people do, but it was a proper rebuttal argument. There's no basis for a mistrial, and it asked the court to deny if that is a motion for a mistrial.
The motion for a mistrial is denied. The state was entitled to argue reasonable inferences arising out of the defense's arguments, and also the definition of superseding causes in the instruction, and the state obviously was entitled to argue that as well. Okay, is there anything else we need to put on the record?
Not from the state, Your Honor.
Okay, why don't you look at the computer, the laptop right now so that I can put on the record that you've had a chance to review it. Defense had a chance to look at the playback equipment.
Yes, we have reviewed the computer. We're satisfied.
Okay. All right. The reason that's important is because the laptop will be provided to. They provided the laptop. It'll be given back to them. It won't be part of the record on appeal, and that's why it's important for the defense to be assured that there's nothing inappropriate on it. Okay. Is there anything else that we need to put on the record? Yes.
Are we expected to stay here till 6 o'clock?
I am going to let the jury deliberate until 6.
Okay, so that means we have to be in
Yes. Okay, anything else? All right, counsel, thank you.